All right, what do we have in front of us now? The state mandated seller's disclosure statement. Boy, do we read all of this. You know what? I'm going to catch the first parts of this. Let's make sure that we understand what it says and what this is all about. Purpose of the statement is a disclosure of the condition of the property in compliance with the Seller Disclosure Act. This statement is a disclosure of the condition and information concerning the properties known by the seller. Unless otherwise advised, the seller does not possess any expertise in construction, architecture, engineering, or any other specific area related to construction or condition of the improvements of the property or the land. Also, unless otherwise advised, the seller has not conducted any inspection of general inaccessible areas such as the foundation or roof. So what it says here is that I'm a homeowner. I am not a licensed contractor, plumber, or anything else to that nature. I know that if I flick this switch, the lights come on, I turn it the other way and they go off. It's that kind of a scenario. Now, that's what they're disclosing. As a homeowner, here's what I know of this property that I'm disclosing on. This statement is not a warranty of any kind by the seller or by any agent representing the seller in this transaction, and is not a substitution for any inspections or warranties the buyer may wish to obtain. And of course, if we're representing the buyer, we know that we recommend that they actually do their own inspections. Okay? Now, here's what it says toward the actual disclosure by the seller. The following information with the knowledge that even though this is not a warranty, the seller specifically makes the following representations based on the seller's knowledge at the signing of this document. Upon receiving the statement from the seller's agent is required to provide a copy to the buyer or the agent of the buyer. The seller authorizes its agent to provide a copy of this statement to any prospective buyer in connection with any actual anticipated sale of the property. The following are representations made solely by the seller and are not representations of the seller's agent, if any. Now, this information is a disclosure only, is not intended to be a part of any contract between buyer and seller. Now, the instructions to the sellers. Talking to them directly. Your job, Mr. and Mrs. Seller, answer all questions. Notice even put it in all caps. Report known conditions affecting the property. So it's the known conditions. They are to attach any additional pages with their signature if additional space is required. Otherwise, if you can't put it all on these 2 pages and you've got to spell out more information, put it on an additional page and attach it and sign it. Number 4 is to complete the form by yourself. So here's what it's telling you, agent. You don't do this. You don't touch this. You don't do any more than basically read the instructions to them. They are to complete it. They are to put the pen to the paper, or if they're doing it digitally, they are the ones to be able to click all of the appropriate blanks. Number 5 is that if some items do not apply to your property, it's check not available. Now, I'll describe that in a second, but let's continue. If you do not know the facts, you are to check unknown. So again, this is a document telling Mr. and Mrs. Seller, here's your instructions. This is how you complete this. Failure to provide a purchaser with a signed disclosure statement will enable a purchaser to terminate an otherwise binding purchase agreement. That is something that they should know and fully understand. Typically not an issue. The only way that this becomes an issue is if for some reason they're not completing the form in a timely basis. Now, let me put this in other words. Mr. and Mrs. Seller If you have a range and oven and it works, you would check yes. If you have a range and oven but it does not work, you click no. If you do not have a range and oven, then it's not available. I want you to be aware of this, guys, because here's what sellers will do. So watch as they begin to complete this, because they complete it incorrectly by going, no, I don't have a range and oven. What they mean was it should have been not available. No, it doesn't work. I don't even have it. Now the other is, again, is what it says, that if you do not know the facts, check unknown. It's telling them to do that. Now here would be a common one. They haven't used the lawn sprinkler system, let's say in 2 summers. Well, then do they know if it works? I've had people say, well, I know it worked when I put it away. I said, do you know if it's working now? Well, I don't know that it's working now. Well, then here's the question. Is it better to check, yes, I know it works, or I don't know? You can always explain it. That is the way they would go through this list all the way through, and it has this line for any explanations that they would have. Unless otherwise agreed, I want you to catch this, unless otherwise agreed, all household appliances are sold in working order except as noted without warranty beyond date of closing. So I'm not telling you it's going to work after closing, but it's worked when I completed this. Now, one other thing to note is right back up here. Guys, this is an important notice. You need to know this is on here. If you're in this for any time, or if you are doing any amount of business, it is likely you're going to run into an agent or a buyer who goes, yeah, but you had the appliances on the disclosure. Here's what the disclosure says. The items below are in working order. The items listed below are included in the sale of the property only if the purchase agreement so provides. I'm highlighting that because you need to know, just because it's on here doesn't mean it's included in the purchase price. Even if you had it on here and you listed it in the MLS, if it's not on the purchase agreement, they are not included. All right? Let's go down to the bottom of page 1. Gets into the property conditions, improvements, additional information. Number 1 is regarding the basement or crawl space, and it says, and here's the question. There's no expanding this. Has there been evidence of water? Look, don't confine that to there has been water in the basement. I have seen it. It says, has there been evidence of water? Folks, that could be staining on any wood, paneling, drywall. You may see staining from water wicking up. That would be evidence. Yes or no? If yes, explain. If we saw water wicking, there's staining on drywall in the basement, staining on lower levels of drywall in basement, and that's all they would do. Insulation. Describe if you know it. How many people know what the insulation is in their house? The only one I know is up in the ceiling. I know it's blown. Couldn't tell you what type of blown-in insulation it is. I can only assume what's in the wall. So they're going to answer it probably unknown. Probably. They go, well, wait a minute, what do I said, well, do you know if there's urea formaldehyde foam insulation? No. Well, do you know it's not there? Well, I don't know that it's not there. So it might be there? Well, I guess it could be. So what are you telling me? Again, I'm simply asking them the questions that will help them fill out the form. I am not going to tell them what to fill out on the form. Roof. Guys, here's all it says. Roof. Leaks? It's a question. The roof. Leaks? I don't know how you expand upon that any more than that. Yes, there are leaks. No, there are not. And then it just simply says the approximate age if you know it. If they don't know, they don't know. And they would put, I don't know, unknown. If they have an idea, they might say approximately. Guys, I had my roof replaced in the last 10 years. That's probably what I would put. The well. Do you know the type of well? The depth, the diameter, the age, any repair history? So anything that they may know of the well, if it exists, they would write down on here. Has the water been tested? Well, it is asking about the well. I guess you could say if I'm on city water, do I need to state anything? Well, I'd ask you, is that the well? When all else fails, look, remember one thing, disclose, disclose, disclose. It's the safest thing for the seller to do. Now, bottom of page 1, they're going to initial. Obviously, we're going to get the buyer's initials at the time of an offer, but we again are going to complete these in detail. We're going to post them into the MLS so that we can get these documents sent over with an offer when it comes to the appropriate buyer. The buyer will then initial. Seller initials, buyer initials when they make an offer. Septic tank or drain fields. Obviously, not applicable if it doesn't have it because it's connected to the city sewer. But if there is a septic tank and drain field, what's the condition to it? They should give anything that they know regarding that septic tank and drain field. The heating system. In particular, saying what's the type and the approximate age. So most are going to be forced air. It might be hot water baseboard, radiant. It could be electric, and they would describe to the type of it. But again, they're just, if they know, what's the age of it. Plumbing system. What do they know? They may be able to actually take and look to see what type of plumbing is in there. And then, do they have any known problems? Are there any known leaks? Is there any known blockages? Again, they're just literally answering the questions. The electrical system. Now, the electrical system is absolutely that. It's all the wiring, the plugs, the light fixtures, the light switches in the house. Do you have any known issues? They would spell that out. Now, number 9 is a bit of a tricky one, so beware of this. History of infestation, if any. Now, termites, carpenter ants, etc. But tell me what infestation means. This alludes to the point that we're thinking that we're talking insects. But let me ask you, are bats, if known in the attic, is that an infestation? You may want to disclose. I'm going to suggest that they do. Because again, history of infestation. It doesn't say exactly what type of infestation. Could be anything. Environmental problems, I think it's exactly that. Are you aware of any substance, materials, products that may be environmental hazards such as, but not limited to asbestos, radon gas, formaldehyde, lead-based paint, fuel or chemical storage tanks, and contaminated soil on the property? But at the same point, it says environmental problems substances, materials, products that may be a hazard, such as, but not limited to. So they think anything could be an environmental hazard. That's where they want to put this and give an explanation if those exist. Do they need flood insurance? That's a simple question. Mineral rights. Do they own the mineral rights? And guys, here's what I'm going to tell you. High percentage of homeowners have no idea whether or not they have mineral rights. Most won't have them. If they do, it's going to be most likely on large parcels. But there was a time period where owners of real property retained the mineral rights. We're going to keep it that simple. What do you think most people are going to have to check? Unless if they know they own them or they know they don't, most people are going to have to check unknown. Features of the property shared in common with adjoining landowners. Do they have any? Any encroachments, easements, or zoning violations, non-conforming uses. Nothing to really expand there. Common areas, facilities like pools, tennis courts, authority going over the property. Again, nothing to expand upon there. Structural modification, alterations, or repairs made without necessary permits or licensed contractors. This one can be a little bit tricky because you may assume that a permit was required, but do you know if it was required? If they ask, what do you provide? I'm going to tell you that, look, if ask me a question as a real estate agent, you my client, if you ask me, well, you know what, I redid the basement myself, but I didn't pull any permits. Well, do you know if you needed to pull any permits? Oh, I don't know. Well, then maybe your answer is unknown. If you know that you were supposed to and you didn't, you're going to click yes. I did some, and I did it without permits. How about 5, settling, flooding, damage, structural upgrading? Obvious major damage by any underground storage tanks, farm operation in the vicinity or proximity to a landfill, airport, shooting range. Now, I don't know what proximity means. How far is it before you're going, yeah, it's not in an approximate area of me? Is it a half mile, a mile? Is it 5 miles? I don't know the answer to that. So what they need to do is use proximity to their own definition, and what they may want to do, if they know of one, well, then you can put Oakland County Airport 5 miles away. What does it hurt? Because pretty much everybody knows that that's there. Any outstanding utility assessments or fees, including the natural gas main extension surcharge. Is there anything that may pass with the property that needs to be aware of? Any outstanding municipal assessments or fees? Again, self-explanatory. Any pending litigation, lis pendens, that could affect the property or the seller's right to convey the property. Of course, here's your explanation for all of it. These two questions look similar, but not the same. This is how long have you lived in the property? This is how long have you owned the property? So I've lived in it since, and it could be that they bought it, leased it out, then moved into it. Could be that they bought it, moved in, and then leased it for the last 5 years. So that's all that should really need to be. Seller certifies information on this statement is true and correct to the best of their knowledge as to the date of the signature. This is just that buyers are advised to make sure that you take a look at everything on your own, use your due diligence, hire an inspector, someone to actually do an inspection and use the due diligence in your own time. Buyers advise that the state equalized value of the property, principal residence exemption information, and other real property tax information is available from the appropriate local assessor's office. Buyers should not assume that the buyer's future tax bills on the property will be the same as the seller's present tax bills. Guys, here's what we've done on our purchase agreement. We actually have the buyer initial that they are likely to go up. Have the conversation with your buyer, guide them, help them make good decisions, and help them prepare for when their payment goes up because they have higher taxes. Bottom line, they need to sign, date, and it doesn't hurt to put the time on that they've actually signed this. Now, there's one thing that you may see out there which is typically incorrect. And that is where somebody will take and go across the face of this, both on page 1 and page 2, never lived in. Most of the time, that is a homeowner, I'll just say it, a homeowner being lazy, and most of the time, that is an investor who bought the property, did a whole lot of work on it, and then is turning around and selling it 90 plus days later and going, yeah, I don't know anything about it. No, they know things about it. Even if they didn't do their own work, they know things about it. So, in the case where you get someone who says, well, we don't know anything about it, that's when you turn to this form here. This has listed out all the circumstances where a seller is exempt from having to complete the seller's disclosure form. There is only one form, to my awareness. We have it in all libraries. It is called the Exemption from the Michigan Seller Disclosure Act. We're going to have the property address and the listing date. So when a homeowner says, well, I don't know, I've never lived here, I'd say, well, no problem. I have a form that will help us cover ourselves from the Seller's Disclosure Act required in the state of Michigan. So what I want you to do is to read through these circumstances, because these would be the individuals that are exempt from having to disclose. So just read through that, initial the ones that apply to you, and then you'll sign at the bottom. What is most likely going to happen? They go, well, none of these apply to me. Oh, well, then you know what that means. You have to complete this. I think that's a very simple discussion at that point. Here it is. The Seller Disclosure Act says these are the following people who are exempt. If you can't initial one of these, you're not exempt. You're not exempt, you must complete the disclosure. So if they do have one of these and they are truly exempt, have them initial it, sign it, date it, and we'll provide it to any buyer who may come along. So with that, guys, seller's disclosure and coverage of the exemptions that exist. I hope you have a fantastic one. See you on the next video, and you know what to do. Go talk to people. See you soon.